Hello, my name is Stephen Brown. I'm an attorney with Reddy & Newman PC here in Houston, Texas. Along with me is our counsel for litigation, Jonathan Wasden. John, one of the biggest issues that's plaguing H-1B employers is that after the February 22nd, 2018 memo, USCIS started an adjudication trend where they're going to give short-term approvals, and some of these approvals are 3 months, 6 months, maybe a year if they're lucky. Yeah. Some are, showing you one today that was expired by the time they got it. We've seen one-day consular processing approvals. Right now the trend is that people just keep refiling these cases. They keep going to the agency, which is costing them money to refile. It's costing money to refile the H-4s that are with it. There's concerns. I mean, if that extension gets denied, now the person's got to leave the country, deal with that. The project might be closed then for them. So other than keep refiling and just hoping we can get lucky with the agency, is there any other solution?
So we've taken several of these short-term approval, partial denials, however you want to call them, to federal court and challenged the agency on these. And they've all so far ended up the same way, which is the agency has two legal problems with what they're doing that a court is hopefully not ever going to allow happen. The first is they're not giving you a written decision explaining why they're shorting you on your time.
Never. It's just
an
take
approval
it.
notice.
They hope you got an approval notice and you're just going to be happy with it.
Yeah. And the other problem is looking at the statute and the regulations, it's questionable whether or not what they're doing is even legal. So when we filed suit on this in the past, what happens is we file the complaint, the government has 60 days to answer in court, and usually well before that time, they've reopened and approved or reopened and sent a new RFE and then approved, and so far they've gotten the full 3 years that they had requested initially.
So I know, you said that one option is they can reopen and issue an RFE, and we've seen some of these RFEs. They go pretty in depth, and like you said earlier, they're basically using that as their way to give the written decision. They're trying to say, here's why we think it should be short, but now, are they really going to go back on that? Or are they going to go ahead and issue a longer approval at that time? What's the purpose of issuing the RFE from the agency's perspective?
So the RFE is kind of a CYA move.
Right.
So the agency, when you sue the agency and you win in federal court, the court may order the agency to pay your attorney's fees.
Yeah, they don't want to do that.
Not so much, especially when the volume of litigation they're facing out right now. So in order to avoid doing that, what they're doing is they're sending out an RFE, and that way they can say, oh, our decision now is based on new evidence that wasn't in the record the first time around, and which takes EJF fees or equal access to justice fees off of the table. So it's really more of a dance that they're going through when they send an RFE out in litigation to try and get away from having to pay attorney's fees.
One of the issues is, USCIS at least justifies this in the policy memo that, hey, we're going to look at the contracts, we're going to look at the letters, we're going to see what's there. And you and I both know, none of these purchase orders are valid for 3 years. No one's got 3 years of guaranteed work on anything. We talked earlier, the government operates on a fiscal year budget. How do we work in this litigation when I've got a contract that's valid for 6 months, because that's the end client's billing cycle is every 6 months, and now I'm going to the court asking for a 3-year approval, and all my documents show 6 months?
Because it's not the contract that you've got that really matters under the law. What really matters is you've signed the LCA as the employer, and you have a legal obligation to pay that person. The statute itself does not require you to have work on hand for them to do. In fact, it says quite the opposite, which is you can put them in a non-productive status if there is no work to do.
But you got to pay them at that time.
But you got to pay them. So the problem with the government is, when they try to argue these things in court, is that the statute is actually against their position, and it's why they haven't really defended a whole lot of these. But to your point about not knowing what you're doing in 3 years from now, we had a hearing in front of a federal court judge, and she just started blasting the government attorney and was like, nobody knows what they're going to be doing in 3 years from now. It's like, This is absurd. This is insane. And I'm like, yeah, I'm glad it's somebody else telling me that as well.
Yeah, we used to just see the 3-year approvals because that's what's in the LCA, that's what's in the I-129, that's what they're allowed to give. And now all of a sudden with this policy memo, which I know is being challenged in and of itself, they go short. So we've seen companies, I've got clients that have refiled 3 times the same year. You and I talked to someone recently who said they filed 3 times in the same 6-month time span. John, that's absurd. There's no way that's what Congress intended to have happen.
When you look at how much they paid in filing fees, attorney fees, and then lost productivity time, those refilings probably all net together a substantial amount of money, probably in the $6,000 to $10,000 range, depending on how involved the case was. And so if you're doing that every couple of months instead of every 3 years, not only does it drive up your cost, but it also makes it impossible for you to plan for the future. What projects can you compete for? And where can you put employees? You don't know, because you don't know if you're going to have an employee around the next extension when they file in 2 months.
Right, that's the problem. With the arbitrary decisions that you could just get that extension approved, the next one denied, now you've got to deal with that. There's a lot of intangible benefits in suing and getting that 3-year approval. It's a lot easier to amend a case than it is to deal with an extension. You're a lot less risk at that amendment stage. So we're working on filing a case here soon on these short-term approvals. And I think that attacking these and getting that 3-month approval to turn into a 3-year approval through getting it reopened and approved, which is the typical court stance, or reopened and send the RFEs so they can do their dance, I think is the best option, rather than keep availing yourself to the agency and giving them the opportunity to deny and continue delaying this 3-year approval approach.
Especially when you take into account that when you file suit, if the agency reopens, then the H-1B is valid. They have work authorization. They have lawful presence.
That's true. Yeah,
that continues on until they issue a new decision.
That's true. So you get that case reopened. The employee gets to go back to work. You can continue beyond that I-94 and let this keep going. And I know you and I have talked. Really, the sweet spot on these, right, is when they've got at least 90 days. That way, they've got that fallback position of, hey, I filed suit, the government, is trending to reopening, we're hoping, but it's getting to that 60th day. And then, if they want to fall back and pull the trigger on filing an extension, they have that option.
Yeah.
Even though typically what we'll see this figured out in that 60 days. But, filing early when they've got that 90 days left will give them that fallback position if they need to.
Exactly. There will be some security built into the litigation calendar, so that if it doesn't work out the way it has in the past, we still have the ability to keep that person working and in status.
Yeah, and we've done that. I know you and I have worked together. We filed one, and I filed the extension right after you filed your lawsuit, just to have on a 9-day. It was a 9-day approval. Yeah. So, filing these lawsuits against this is another way to go against the agency. To fight them on them going well past what's allowed by statute and that they should be doing. So please, if you have questions on this and want to be part of this litigation, please contact us at readynewmanpc@rnlawgroup.com, and we'd be happy to answer any of your questions.